Hello, my name is Loizou and I'm a partner at the International Family Law Group. Today I'll be speaking about freezing orders in an international context. I am a colleague at IFLG of David Hodson, who is the author of the International Family Law Practice Guide 2015-16. This has recently been released by Jordans, and it's the content of that this podcast is based. So looking at freezing orders in the international context, a freezing order was formerly known as a Moravia injunction, and it's a discretionary interim order that the court has and has the power to make, which basically prevents the disposal of assets by a party during proceedings. These orders are often made by the family court, and their role really is to preserve assets in the divorce case for the purposes of implementation and enforcement. Increasingly, worldwide freezing orders are being used. It's basically to restrain dealings with foreign assets. It's very much a vital tool in the family solicitor's toolbox to be able to apply for a freezing order and to be able to obtain one effectively, because it's easy for people to squirrel away assets, which then makes it very difficult to enforce any order that you obtain. Also, in the last 5 to 10 years, the world has changed. It's very easy to transfer funds across the world at a click of a button. So it's very important that as family lawyers we're able to take effective and efficient steps. In some European countries, when a party or a couple separates, the assets are automatically frozen pending separation. But in England, this doesn't apply. The basic rule here is that everyone has the basic right of peaceful enjoyment of their possessions. And so great care must be taken when you are applying for a freezing order. You must be able to show that there are clear objective facts that assets will be dissipated. One thing I would say is that the law in the last 5 years has changed with regards to freezing orders, and particularly without notice injunctions. Courts have become very critical of family lawyers who make applications that aren't warranted and those that are made without notice, so you must take great care. So what's the court's jurisdiction to make freezing orders? The court has the power to make a freezing order either under Section 37 of the Matrimonial Causes Act 1973 or through its inherent powers. Usually what happens is you choose a combination of both of these powers. But if you're applying for an international freezing order, usually using the inherent jurisdiction provisions is better for you and your client. So let's look at worldwide freezing orders. Generally, the courts have been very reluctant to make these types of orders unless there are exceptional circumstances. So we need to take care as lawyers of our own positions to make sure that we're not left exposed. Usually what happens is there are proceedings in England, but there are also proceedings abroad. And you need to coordinate the use of lawyers in this country, but also of those in another jurisdiction. You should never underestimate the cost of obtaining an international freezing order, and what's absolutely fundamental is that you get proper costs estimates up front for your clients so that you know exactly how much things will cost before you start the process. So what do you have to show in order to obtain a worldwide freezing order? Well, there are 4 requirements. The first is that there are not sufficient assets in this jurisdiction in order to meet your client's claim. Secondly, you have to have a good arguable case. Thirdly, you need to ensure that there are actually assets abroad. And finally, you need to show that there is a real risk of dissipation that would make any subsequent order valueless. A few general points for practitioners to remember. If you're thinking of applying for a worldwide freezing order, one of the cases you need to read is Dodorian and Sims, and I deal with this in a little bit more detail shortly. You should find out from your foreign lawyers what words, clauses, recitals you should put in your English order, which will make implementation and enforcement easier later on. You should also look at obtaining mirror orders in the other country to ensure that your English order is enforceable. Now, I mentioned the case of Dodorian, and this is a must-read for all lawyers when you're thinking of applying for an international freezing order. This is a Court of Appeal judgment, and the Court of Appeal basically set out 8 principles and guidelines for when applications are made for these types of orders. And as I say, it's very important that you read this before you apply for a worldwide freezing order. These orders tend to be very complex. Worldwide freezers are difficult to obtain, and therefore it's important that you have all of your rows, your ducks lined up in one row before you take the step of going to court to make that application. At the International Family Law Group, we specialise in these applications if they're needed, and so please feel free to contact any one of our lawyers at the firm if you need any assistance on this topic. Thank you.